Hello, everybody. In behalf of the NBSAP Forum, I want to welcome you all to this session. I am Diego Ochoa on behalf of Cristina Sopols. I would like to thank you for attending our March webinar series dedicated to legal preparedness for implementing NBSAPs. The first webinar in this series is about protected areas, law, and governance, presented by Dr. Alexander Paterson from the University of Cape Town. Laws have the ability to catalyze prompt, focused, and coordinated actions to mainstream biodiversity values across sectors and society. Given pressures on terrestrial and marine environments, countries are encouraged to develop legal frameworks that effectively facilitate the implementation of the Convention on Biological Diversity. NBSAPs are the key conduit for implementing the CBD's strategic plan for biodiversity and are a central policy-making tool for national biodiversity management. This March, the NBSAP Forum is hosting a four-part webinar series to support countries to legally prepare themselves to implement NBSAPs. Understanding the notion of governance is a key prerequisite to developing and implementing an effective and equitable protected area legal framework. The concept is also of key relevance to practitioners that are developing and implementing NBSAP strategies and actions related to protected areas. During this webinar, Dr. Paterson will provide a broad introduction to the concept of governance in the context of protected areas. He will also canvass these five main issues: the concept of governance, legal factors influencing protected areas governance, relevant international laws and policies, protected areas governance types, and linkages between governance and other generic legal elements found in protected areas legislation. Dr. Alexander Paterson is a professor of environmental law based in the Institute of Marine and Environmental Law, Faculty of Law of the University of Cape Town, where he combines the postgraduate programs specializing in marine and environmental law. Dr. Alexander is associated with several reputed international organizations, commissions, and journals on environmental law. Welcome, Dr. Paterson, and thank you for attending this invitation. It's really a pleasure to have you here today. As usual, before starting, I just want to remind you all some rules and dynamics in the NBSAP Forum webinar. Microphones will be mute during the presentation. This reduces interferences and facilitates the communications. We will have a 1-hour presentation followed by 30 minutes of questions and discussions. Please send us in advance your questions or raise your hand in the control panel. If you want to speak and the connection allows, we will open the participants' microphones to promote interaction during the Q&A sessions. As many of our participants are not English native speakers, me included, I would like to remind our speakers the importance to talk slower. This fosters the comprehension among our practitioners. As you know, this session is being recorded and it will be available at the NBSAP Forum website. All the participants will receive an email with a link to watch it, as well as a PDF copy of the presentation and a list of resources related to the topic. Now, I will transfer the webinar to Dr. Paterson. Please enjoy this session and welcome Dr. Paterson to this NBSAP Forum webinar series.
Thank you, Diego. Can I just confirm that you can hear me clearly?
Definitely.
That's great. Well, welcome and greetings from South Africa. There are a couple of things which I would like to begin with before we start with the substance of the webinar. The first is that I feel a little like this small child, as this is very much my first webinar, my first experience into the world of online teaching and learning. Or perhaps I feel a little bit more like this picture, the child in this picture, as I feel as though I'm sitting here talking to myself, looking at myself in a mirror, Diego has confirmed that there are people out there listening. But what concerns me is that when one is talking to oneself, people say it is often the first sign of insanity. So I'm very much hoping that my colleagues do not walk into the office and see me here talking to my screen by myself. Issues which we are going to unpack in the course of the next 60 minutes are very, very complex. And I sometimes feel a little like this man trying to push this large stone uphill. It is a very large task, and all I can really seek to do in the next 60 minutes is briefly introduce you to some of the main concepts. I would like to set some important context to the content of this particular presentation in this webinar and certain of the subsequent presentations, in particular webinar 3 and 4. They stem from a large project which has been undertaken by the IUCN, Environmental Law Centre's Protected Areas Law Program, over the past 6 years. And these projects have been undertaken in two big phases. The first phase ran from 2011 up until about 2013, and it was involved in trying to create a set of guidance on protected areas legislation and legal aspects of connectivity conservation. And the outcomes of these particular projects were published in the set of two documents. The first, the Guidelines for Protected Areas Legislation, and the second in 2013, a concept paper on the legal aspects of connectivity conservation. Very important documents which are freely accessible via the IUCN Environmental Law Centre's website. The second phase of the project related to trying to bring life to many of the contents contained in these two documents, aimed at building capacity, or what we termed as those tasked with developing these resources, protected areas law literacy. And we sought to do that through creating a series of resources which are all readily and freely available to anyone who wishes to utilize them. These resources are available on this particular platform. It is called protectedareaslaw.org, and it effectively contains 12 modules. 12 modules aimed at building capacity on protected areas law and governance. The first 6 of these modules, which you could call the core modules of the particular course, focus on those 6 main issues. The subsequent 6 modules seek to focus on certain specific issues. Module 7 focuses on international and regional law relevant to protected areas. Modules 8 and 9, which form the focus of webinar 3 in this series, focus on connectivity conservation. Modules 11, which focus on marine protected areas, will form the focus of seminar or webinar 4 in this series. And the final module, which touches on transboundary protected areas, will also be touched on in the context of webinar 3, dealing with connectivity. Each of these particular modules, which are freely accessible, contain a seminar presentation, which we hope does not send people to sleep as in that particular picture, together with a series of practical exercises. The seminar presentation seeking in an interactive manner to transfer knowledge on protected areas law, and the exercises seeking to build practical skills using the knowledge conveyed in the seminar presentation. So for each of these particular 12 modules, the resources which are available include a module outline, a seminar presentation with the presentation itself, including all the presenters' notes relating to the contents in the presentation, and a series of exercises, both an outline for the exercises and all the relevant resources which you need to either undertake those exercises yourself or run those exercises in the form of a training session. These exercises include legal drafting exercises, role plays, discussion forums, and various case studies, all seeking to take different aspects of protected areas law and illustrate how one can build practical legal skills around protected areas law and governance. The resources which are available also include various media resources, such as interviews and documentaries, and information graphics, which one can seek to integrate in your knowledge building exercise, whether you're seeking to undertake it personally or are you seeking to develop a course to present these and build capacities in others. So that's the end of my advert. To remind you that all the resources which follow, developed under the auspices of the IUCN Environmental Law Center's Protected Areas Law Program, can be found at this particular website. And I emphasize everything available at www.protectedareaslaw.org is freely accessible for you to use and enjoy. So let's begin with this particular webinar. If there are various take-home points, which I hope you remember following this brief introduction, they are as follows. Protected areas are central components of any national biodiversity strategy and action plan. Governance is recognized as central to protected areas. And understanding of protected areas governance is growing, and as I will highlight, that understanding rarely was initiated as recently as 2003. Protected areas governance is concerned with authority, and that authority is often founded in the law. So if one wants to properly understand protected areas governance, understanding the law is of key relevance. And understanding protected areas, the law and governance are therefore of key relevance to national biodiversity strategy and action plans, particularly to those who are seeking to formulate those NBSAPs and those who are seeking to implement them. So as Diego has emphasized, this webinar is seeking to tackle 5 main issues. Firstly, to start by generating an understanding of what is governance, what is protected areas governance, what is the relationship and the difference between the two. Secondly, to look at an array of legal aspects which influence protected areas governance. Thirdly, to look at a set of relevant international laws and policies which have increased the focus on protected areas law and governance in the course of the last decade or so. Fourthly, to look at different protected areas governance types, and particularly the role of law in giving effect to those different governance types. And finally, to look at the link between the many other elements one finds in protected areas laws and how protected areas governance impacts on those protected areas law elements. So let us start with the first of these issues, the most basic, or perhaps the most complex. What is governance? There are many definitions of what constitutes governance, and I have selected this one, which one finds in the IUCN Protected Areas Governance Guidelines. It is as follows. Governance is the interactions among structures, processes, and traditions that determine how power and responsibilities are exercised, how decisions are taken, and how citizens or other stakeholders have their say. Now, what should be immediately evident or clear from that particular definition is that authority or power through such decision-making is central to governance. What should also be clear is that governance is a complex concept. It is rich and multifaceted, There are many structures, there are many processes, there are many different traditions, many different forms of power and authorities and actors who are exercising that authority and power. But if one distills it to 4 essential elements, it is the following. Governance involves who makes decisions, how decisions are made, how authority is shared, and who is accountable for the decisions which are made. Governance, some commentators believe, can comprise of 2 different dimensions. There's the one aspect which deals with the quality of governance. Is the authority exercised well or not so well? Here we are dealing with something called good governance, which relates to the quality of the governance. A second dimension relates to who is in fact making the decisions. And this particular dimension is commonly referred to as different types of governance, different types of ways in which decisions are made. If one takes those 2 dimensions further, governance or good governance, and the right reflecting who makes decisions or types of governance, there are a number of sub-factors which need to be taken into account. In order to achieve a good quality of governance or good governance, a legal framework should make provision for public participation. It should ensure that decision-making is undertaken in a transparent manner. It is undertaken in a predictable manner. That the outcome of the decision achieves issues of equity and justice. And if justice is not achieved, that the relevant mechanisms are contained in the law to allow people to challenge that decision-making, if that decision-making is not good. Each of these particular aspects would need to form the focus of an aspect in the relevant legal framework, as if they are not addressed in the relevant legal framework, it may be impossible to achieve good governance. The second dimension relating to types of governance. There are 3 broad overarching types of governance. Governance can be centralized, as in undertaken by the government or state. Governance can be decentralized, as in undertaken by non-state actors or non-government actors, such as individual citizens, companies, NGOs, indigenous communities. Governance can also be shared. Decision-making can be shared between state entities and non-state entities. Another fundamental distinction which needs to be laid out at the outset is the distinction between governance and management. When we're dealing with governance, we're dealing with the question about who decides about what is to be done, and more so, how these decisions are in fact taken. When one is dealing with management, one is dealing with what is actually done in pursuit of given objectives. So in the context of management, one is looking at outcomes and outputs. And in the context of governance, one is often dealing with processes. Having outlined what is governance, we are now in a position to look at what is protected areas governance, and utilizing that same definition which I did at the outset. Protected areas governance can be defined as the interactions among structures, processes, and traditions that determine how power and responsibility are exercised, how decisions are taken, and how citizens or other stakeholders have their say in the particular context of protected areas. We are again dealing with authority or power. Here, that authority of power may either be de jure or de facto. De jure referring to the fact that that power stems from law. De facto referring to the situation where that power does not stem from a law, but stems from practice. power we are referring to here, or the authority we are referring to here, again relates to those four aspects. Who makes decisions regarding protected areas? How these decisions are made? Is authority shared between many different role players in the context of protected areas? And how are these decision makers held accountable or responsible for their decision making? In the context of protected areas governance, there are many influential factors. One may be looking at many different types of decisions. A decision, for example, whether to establish a protected area, or a decision how to manage a protected area. We are often dealing with many actors. These actors, as I've mentioned previously, can include government actors or non-government actors. We are dealing with many different instruments or tools. One of these tools would be a law which grants particular actors authority to make different types of decisions. We are often dealing with many different types of powers or authority. These may be powers such as to plan for a protected area, to manage a protected area, to enforce compliance with the law in respect of a protected area. And this power or authority is often undertaken at different levels. These levels could range from the international level through to the regional, the national or federal, or through to the state or local level. At its most smaller scale, we could be dealing with decision-making undertaken in a particular site, a particular protected area. Now, if one thinks that those are 5 key influential factors for protected areas governance, what is the role of law? What does the law do? Well, the law has a central role to play. The law often indicates what types of decisions can be made by different entities or different actors. The law will often identify these actors. It may even create these actors by creating the institutions. The law is one of the instruments or the tools through which decisions are made. The law will set out what is the power or authority, the different types of power or authority, and who is empowered to exercise that authority. And the law often sets out at what level decisions should be made. Some decisions being left to national actors, some to state or provincial actors, some to local actors, some to non-state actors. If there were 4 general lessons to emerge from an understanding of governance, they are the following. Protected areas governance is the result of a process of developing and exercising authority over time. It is therefore not a short-term perspective, but a long-term perspective. Secondly, understanding protected areas governance involves clarifying where rights, responsibilities, and accountabilities lie. And it is here that the key role of law comes to the fore, because law has a key role to play in providing that particular clarity as to rights, responsibilities, and accountabilities. Thirdly, a dynamic and mutually supportive balance among many actors and institutions should be sought through powers and instruments exercised at different levels. So it is often a balance between these actors. There may be competing actors, there may be complementary actors and institutions. And this balance is often playing out at different levels. It could be at the international, the regional, the national, the local, or a site-specific level. And finally, governance systems should be dependable but also adaptable, capable of responding to the ever-changing needs of in-situ conservation. And this poses a potential challenge to lawmakers. Lawyers and lawmakers like certainty, but in developing laws which seek to give practical effect to protected areas governance, elements of flexibility have to be embedded into the legal system to enable it to evolve and adapt to changing circumstances. When one thinks of protected areas governance and different types of authority playing out in protected areas, they can be reflected on a continuum of options. On the left-hand side, we have state in full control, the government in full control. And that was the historic approach to protected areas, with states exercising or governments exercising control over protected areas, creating the protected areas and managing the protected areas. On the opposite end of the spectrum, on the right-hand side, we have a situation where the control or authority over protected area does not fall in state actors' hands. It falls in non-state actors' hands. And in the middle, we have a set of shared options where authority or power over protected area is shared between different actors, state actors and non-state actors. So on the left-hand side, we have the historic approach, state-owned or state-controlled protected areas. On the right-hand side, we have the new emerging forms of protected areas, which have received much attention in the last decade. Indigenous peoples and local community conserved areas or private protected areas. And in the middle, we have shared forms of governance. These are called sometimes co-managed protected areas. They are shared. A particular characteristic is that authority and power in the protected area is shared between different authorities. Why this is reflected as a continuum is that a particular governance arrangement in a protected area may shift over time. It may start as a state-owned or state-controlled protected area and shift to a shared form of governance. Similarly, an area which was previously a private, subject to private governance or control by a particular private entity may move into a more shared form of governance. There's that element of flexibility embedded in the broader notion of protected areas governance. So historically, governance in protected areas was focused on the left-hand side. And in the course of the last decade, much attention has been focused on shared forms of protected areas governance and governance by Indigenous peoples, local communities, and other private actors. So I hope you have now a slight better understanding of this notion of governance, what it is, the factors which influence it, what is protected areas governance, and how it is a continuum of options. I now briefly want to touch on legal aspects influencing protected areas governance. This is a webinar on the role of law, and often when one reads international governance guidelines, the law is not accorded significant attention in those guidelines. But as I've mentioned, if protected areas governance is about authority, and authority is often founded or sourced from the law, one needs to understand these legal aspects in order to understand the governance arrangements in operation in a particular protected area. Let's take an example. The W Biosphere Reserve, a transboundary biosphere initiative which spans Niger, Burkina Faso, and Benin in Central Africa. It's often difficult to categorize specific types of protected areas governance or legal factors impacting or shaping on protected areas governance due to the diversity of actors, instruments, powers, types of decision-making, and levels at which this decision-making takes place. But this is one way one can think about trying to understand protected areas governance and the impact of law. There are a number of contextual legal issues which may impact on that particular biosphere reserve. These contextual issues are not site-specific, they stem from the broader context. On the other hand, we have a series of site-specific factors. These factors are relevance to that particular site, that particular biosphere reserve. If one's dealing with the contextual factors, we can think of international issues, regional issues, and constitutional legal issues. And when one's dealing with site-specific factors, we can think of ownership issues. Who owns the land in that particular set of protected areas? Management issues. Who is responsible for managing the land and the resources situated within the protected area? and access, use, and benefit sharing issues. Who holds the rights and is accountable for the responsibilities of costs associated with the land and resources situated within the particular protected area? These things are all about authority, and law underpins authority. So let us look at each of these particular legal aspects in more detail. Firstly, looking at the contextual legal aspects, and then looking at the site-specific legal aspects. The contextual legal aspects can be broken down into three different parts. There is the international context, which may shape what happens in that biosphere reserve. There may be relevant international instruments, conventions or protocols or guidelines or decisions which impact on what people do, what they're able to do, how they structure their arrangements to manage that particular biosphere reserve. There may also be relevant international institutions which have a role to play in how things transpire in that particular biosphere reserve. Similarly, there may be regional instruments, such as regional agreements, which influence arrangements in that particular biosphere reserve. And there may be regional institutions tasked with implementing these regional agreements. The third contextual legal aspect relates to constitutional issues. They're often relevant substantive rights, such as environmental rights, or property rights, or customary rights, which are embedded in different countries' constitutions, which shape what happens in that particular biosphere reserve. There may be procedural rights, such as just administrative action to challenge decision-making, access to information, to promote transparency and predictability, locus standi or standing to challenge decisions. These procedural rights need to be borne in mind or kept in mind because they similarly influence how decisions are made and how decisions can be challenged, those decisions relating, in this example, to the biosphere reserve. And thirdly, from a constitutional perspective, one needs to understand how the Constitution lays out the lawmaking powers and the administrative powers of different parts of government to both make the laws, administer the laws, and often how they cooperate amongst one another to ensure that they're not operating in different ways which would effectively undermine what's happening in the context of that biosphere reserve. Looking at the site-specific legal factors, which one needs to understand in order to understand authority in a protected area, these become complex. That border represents the biosphere reserve. Within that biosphere reserve, there are those three site-specific factors: the land tenure or ownership arrangements, the management arrangements, and the arrangements for dealing with access and use of the resources situated in that particular biosphere reserve, and the sharing of benefits derived from the use of that access and use. Each of these particular site-specific factors have two subcomponents, a question of who and a question of how. In respect of land tenure, the who question relates to who owns or holds the rights in respect of the land or the resources situated in the biosphere reserve. The government may hold those rights, a community may hold those rights, or an individual may hold those rights. They may hold them individually, or they may hold them in a group, communally. In the context of management, who is undertaking that management? The management may be undertaken by a government entity, again by a community, or alternatively by an individual. They could each be undertaking that management individually, or they could be seeking to cooperate in their management in a communal sense, a shared sense, and here we move into those shared notions of governance. There could be a sharing arrangement, a co-management arrangement between a community and a government entity, or between an individual role player and the government. In the context of access and use, once again there are those three potential role players who may seek to operate singly or together in some communal sense. Turning to the second component, how, in the context of land tenure, How is that land tenure created? How are the ownership rights or the resource rights created? Are they created by a law or a statute? Are they created by custom or customary law? Are they created by a contract or an agreement? Looking at the form, does the statute or the law or the custom or the contract grant those particular entities full title, the full set of rights, or some limited title to the resources and the land situated in that particular protected area? In the context of management, if one's thinking of the basis on which management authority is founded, that management authority may stem or arise or be created by, again, as law, custom or customary law, or some form of contractual arrangement. And that management may be undertaken singly, or where there are multiple actors, could be undertaken in a co-managed manner, or jointly, or there could be some transboundary management arrangement, such as in the context of that biosphere reserve, which is a transboundary initiative. And finally, when one's dealing with access and use, how we're looking at where one creates or founds the authority to access the area, use the area, and share the benefits derived from such access and use. Those rights may stem again or arise or be created by law, by custom or customary law, or by contract. And they may differ in form substantially. The law may enable authorities to lease certain rights or grant those rights through a permit or a concession or a commercial joint venture type agreement. And these are the factors, the legal aspects, which one seriously needs to unpack in order to properly understand the forms of authority, how that authority is operating, and by whom in the context of a protected area. Because if one doesn't understand the myriad of these particular aspects influencing or shaping authority in a particular protected area, one will often struggle to properly understand the governance arrangements in a protected area. So those are some of the broad legal aspects influencing protected areas governance, both the contextual aspects and the site-specific aspects. I'm going to now turn to the third component of this particular webinar, which are the relevant international laws and policies, those relevant to particularly protected areas law and governance. On the left, we have some important dates, starting in 2003, and I've brought them up to contemporary times to 2016, the end of 2016. These are the important dates in what I would call the developing protected areas governance discourse, the important dates on which various events happened and various documents were released, which are of key relevance to protected areas governance and the role of law in facilitating protected areas governance, or effective and equitable protected areas governance. The first important date was 2003. It was the World Parks Congress, held in Durban, South Africa, and it was at this particular conference that the issue of protected areas governance came to the fore, gained momentum. Much of the focus there was on the recognition of a need to properly understand protected areas governance, and a realization that state-controlled protected areas were not going to achieve the solution. Various parties there were tasked with exploring the issue. A year later, the IUCN prepared a set of guidelines on indigenous and local communities and protected areas. This reflecting a clear recognition by the international community that state-managed protected areas were not the only solution. There was a need to acknowledge the role of those protected areas which were subject to authority or oversight by indigenous peoples and local communities. The importance of indigenous peoples and local community conserved areas was once again acknowledged at COP7 of the CBD, held in 2004, and was particularly reflected in PARPA, the Program of Work on Protected Areas. And if you're interested, you can go and look at Program Element 2, which is all focused on the effective participation of indigenous peoples and local communities and that form of governance in the context of protected areas. At the IUCN World Conservation Congress in 2008, the idea of indigenous people and local communities and their important role played in governance was again endorsed, but more so the role of private actors in the context of private protected areas or private forms of governance was heightened. It was also shortly thereafter that the guidelines on applying protected areas management categories were launched, and embedded in these particular guidelines on protected areas management categories was a set of governance types which we will explore in a moment. These governance types were endorsed at COP9 of the Convention on Biological Diversity in 2008. "2010 saw the release of the Aichi targets at the CBD COP10, and if one reflects on the content of many of those Aichi targets, particularly Aichi target 11, 14, and 18, they are of relevance to protected areas governance, and once again a recognition of the need to promote diverse forms of protected areas governance. 2011 saw the release of the IUCN Guidelines on Protected Areas legislation, one of the documents I've previously referred to, which is all about the role of law in promoting effective and equitable protected areas. And there's an entire chapter dedicated to focus on protected areas governance in that particular publication. 2012, the importance of protected areas governance was again endorsed at the IUCN World Conservation Congress and the CBD COP11. But one additional particular aspect which arose at these international events was the idea of a need to focus on good governance, because focusing on different types of protected areas governance was one thing, but one needed to ensure that that governance was operating in an effective and equitable manner. 2013 saw the release of the IUCN Governance of Protected Areas Guidelines, an entire set of guidelines focused on protected areas governance. 2014, at the IUCN World Parks Congress held in Sydney in November 2014, one of the 8 main streams was particularly to focus on enhancing diversity and the quality of governance, therefore building on this additional focus on good governance, which had initiated back 3 years previously. This was once again endorsed at the CBD COP12. And finally, if one looks at the proceedings and recommendations emanating from the World Conservation Congress held in Hawaii last year and the CBD COP held in Cancun last year, you'll note that many of the decisions emanating and recommendations emanating from these particular events also reflect the importance of protected areas governance and the role of law. So if one looks from 2003 through to 2016, in a mere 13 years, there has been significant attention devoted to this idea of protected areas governance, understanding what is protected areas governance, understanding issues of good governance, and focusing on the role of law in promoting different governance types and also promoting good governance. So there are diverse forms of governance. And this idea of good forms, of diverse forms of protected areas governance is not only reflected in the conservation realm, it's also supported by other international laws and policies outside of those developed by the IUCN or outside of those developed by the CBD COPs. In the realm of the environment, you'll find reference to governance and governance diversity in the World Heritage Convention and the Ramsar Convention. And one will also find important reflections in the human rights instruments. The ILO Convention 169 is an important document because it reflects a definition of what constitutes indigenous peoples. The UN Declaration on the Rights of Indigenous Peoples of 2007 significantly raised international focus on the tenure and resource rights of these indigenous peoples, which no doubt contributed and filtered into the discussions around protected areas governance and the particular role of these indigenous people in governing those particular resources situated in protected areas. So those are some of the relevant international laws and policies of relevance to protected areas governance. Much of the attention has been on discerning or developing a set of protected areas governance types. And I'm going to spend the next 10 minutes focusing on these different governance types, and particularly the role of law in ensuring that these governance types are enabled by a legal framework, or how to enable them through a legal framework. Where do we find these protected areas governance types? Well, there are two important documents which I've just referred to. The first are the guidelines for applying protected areas management categories developed by Dudley initially in 2008 and updated in 2013. And then the Governance of Protected Areas guidelines developed in 2013. There's a slight difference between these two documents which is important to understand. The one on the left, the guidelines for applying protected areas management categories, the older of the two, contains details on both the management categories of protected areas and the governance types of protected areas. And therefore one needs to understand what is the distinction between the management categories and the governance types. As I've indicated when I drew an initial distinction between management and governance, that distinction similarly applies here. Management categories are a set of 6 categories contained in these particular guidelines, which deal with the management objectives for a protected area. So management categories are dealing with management objectives of a protected area. The governance types, on the other hand, governance relating to authority, deal with the different governance arrangements operating within a particular protected area, dealing with authority. The document on the right does not deal with the management categories, it only deals with the governance types, as its title suggests, governance of protected areas. It contains more details relating to governance types, and in addition to that, how to promote good governance in the context of protected areas. This particular diagram taken from these guidelines reflects the different governance types, type A, B, C, and D on the left-hand side, and then a set of 13 different subtypes into which these 4 broad governance types can be broken down. At the top, type A, we have governance by government. That's the historic or the traditional one, where governance or authority in a protected area is undertaken by a state or government entity. Below that, we have the shared forms of governance, where authority is shared between different actors. Below that, type C, we have private governance, where governance in a protected area or authority in a protected area is undertaken by non-state actors. And type D, which has been the focus, as you would have seen through my survey of the international legal framework, of much of the attention, is dealing with governance by indigenous peoples and local communities. So these 4 broad governance types can be broken down into subcategories. Governance by government can be broken down into 3 subcategories, where that authority is exercised either by a national entity or by a subnational entity or by an entity to whom government has delegated that authority in terms of the law. In the context of shared governance, a distinction is drawn between transboundary governance, which is where we have a transboundary initiative in a protected area spanning the boundary of 2 states. One will need an arrangement to deal with how to exercise authority across that boundary, to deal with that particular transboundary protected area. There's collaborative governance, and here we're dealing with one entity accorded the authority in respect of a protected area, but for instance having to consult with another entity. And the final subcategory there is joint governance, where you effectively have many actors sitting on a joint management authority, or an authority jointly responsible for making decisions in respect of a protected area. So it's much more than collaborative governance, which is just mere consultation. Joint governance is where that is actually exercised jointly through a joint decision-making process. In the context of private governance, there's a distinction between individuals exercising authority in a protected area, that authority being undertaken by a corporation or a company, or that authority being undertaken by an NGO, a non-government organization. And in the context of governance by indigenous peoples and local communities, a distinction is drawn between indigenous peoples and local communities, as is characteristic of many of the instruments seeking to draw a distinction between those two groupings. Before I look at each of those in more detail, and particularly the role of law in giving effect to them, it's important to understand a set of general issues related to these particular governance types. The basis here of distinguishing the different governance types is authority and responsibility. We are not dealing here with management objectives of protected areas. The governance types do not necessarily relate to ownership or holding of rights. So there may be a distinction between who exercises authority and who owns the land or the resources situated in a particular protected area. Sometimes they will overlap, but sometimes they may not. The determination of the governance types is often far more complex than determining a management category for a particular protected area, due to the fact that there are many different sources of management authority and responsibility operating in a particular protected area. There may well, in fact, be many different governance types operating within the borders of one particular protected area. It's also important to emphasize that in the context of governance types, we often don't find these particular names of these governance types reflected in protected areas laws. Often we find different legal mechanisms or tools for facilitating the implementation. Now, this is very distinct to the management categories, because often the management categories are reflected exactly as they're depicted in the international guidelines in protected areas legislation. And finally, if we determine the governance type of a particular protected area, that is something distinct from working out if the governance in that particular protected area constitutes good governance or quality governance. Those are two distinct things. What I now want to do is briefly look at each of these governance types, starting with the historic or the traditional one, state governance or governance by government. Here, as I've mentioned, is the classic approach, where the protected area is state-owned, it's state-controlled, and these are generally formally recognized in protected areas legislation and part of the protected areas state or a particular country's protected areas estate. I've introduced you to the nature of the subcategories, the national forms, the subnational forms, and those forms where they are delegated particular functionary. Now, what is the role of law in giving effect to this particular form or this particular governance type? Well, these are the ones which are generally formally included in protected areas legislation or recognized through protected areas legislation. And what does the protected area law do? Or what should it do? The law should provide for their declaration. The law should set out the arrangement for managing them. The law should create the institutions for managing them and set out the powers, functions, and composition of that particular institution. The law should set out how activities are regulated in this particular form of protected area, this particular type of protected area. It should furthermore set out how one ensures that there is compliance with the relevant legal framework, and where there's not compliance, what mechanisms are created to enforce that compliance. So in the context of this particular governance type, the law clearly has a crucial role to play. Looking at shared governance, where we're dealing with that shared authority across several actors or across international boundaries feasibly in the context of transboundary governance, here we may be dealing with processes which are formal or processes which are informal. And we're also dealing with many different types of sharing. These types of sharing are mimicked by the different subcategories. There's the transboundary governance, form of shared governance, where we're dealing with an arrangement across a sovereign boundary or across the boundary of two countries. There is collaborative governance, where we're simply dealing with authority being held by one particular entity with mandatory consultation with other particular institutions or actors. And then there is joint governance, where we create particular mechanisms or institutions which jointly exercise decision-making in respect of a particular protected area. They share that decision-making, they share that authority. Now, the legal considerations here, which one needs to take into account in formulating or implementing a protected areas law, are the following. The form of sharing needs to be clearly delineated or created in the particular protected areas law. The mechanisms for sharing such authority need to be created. Is this provided for by way of the conclusion of an agreement? Is it provided for by the creation of joint decision-making committees or institutions? Does the law provide for mandatory or discretionary consultation across different actors? These issues need to be governed clearly by the law. The law needs to set out the institutions which exercise that shared power. It needs to set out their composition, their powers and functions, the different roles and responsibilities of the different actors, how decisions are made. Are they made by majority or are they made by absolute consensus? This is the certainty the law needs to create. The law, or other programs, also need to ensure that those actors who are party to these shared authority arrangements have the relevant capacity, resources, or support to operate, to play a role in those joint or collaborative decision-making processes. And as I've mentioned previously, due to the flexibility necessary as different governance types can evolve and shift across that continuum over time, the law needs to embed some form of flexibility into the particular legal arrangement to provide for that shifting across the governance types over time. Looking at private governance, what is its nature? Well, here we move into the world of voluntary conservation. Often we're dealing with private landowners or private entities who are willing or voluntarily willing to grant their particular resources or contribute their particular land or resources into a particular protected area. These areas are sometimes included in the formal protected areas system and sometimes not. There are the different categories dependent on who undertakes the initiative, whether it's an individual landowner, company, or a corporation, or non-government organization. And what must the law do in order to give effect to this particular form of governance? Well, it needs to clearly set out if this particular form of governance, private governance, constitutes forms of protected areas for inclusion in the formal protected area system. Will they be granted legal recognition or will they not? The law needs to clearly define what types of areas can fall within this type of governance. These areas are given many different names. Some laws refer to them as private protected areas, others private conservancies, others private parks or private reserves. These definitions need to be created in the law. The law needs to clearly set out what are the different forms of private governance, because there are many different forms this form of private governance can take. It could comprise of an individual landowner willing to give their land over to the government to include in a protected area. It could include an individual landowner willing to undertake the management of land owned by the state. It could include an NGO seeking to purchase land or accrue land through donation and manage that land as a protected area. So given this diversity of forms, the lawmaker needs to work out which of these the policymakers wish to include within the protected area law in order to accord them formal legal recognition. The law also needs to contain the mechanism for securing the land. These mechanisms vary. These mechanisms can include easements or servitudes or covenants or management agreements or land use planning arrangements or permitting schemes. So the types of particular legal mechanisms for securing that land in the long term within a formal protected area are diverse, and the policymakers need to think carefully about which of these particular legal mechanisms they wish to use. The law also needs to set out who is responsible for managing the areas and the legal mechanisms for holding them accountable. And finally, given that these are voluntary initiatives, the law often needs to create incentives to encourage these non-state actors to play a role in either the management of the protected area or decide to contribute their land into a formal protected area system. The final form of governance type is governance by indigenous people and local communities. As I've mentioned, this particular governance type has been the focus of much recent attention. Here we are dealing with land owned or controlled or resources owned or controlled by indigenous peoples or local communities. Again, as in the context of private protected areas, the law may decide to recognize this particular form of governance as part of the formal protected area system. It may choose not to, however. Looking at the nature of the subcategories, there are the two subcategories, those constituting indigenous people conserved territories and areas, and those constituting community conserved areas and territories. Often these are jointly referred to as ICCAs, Indigenous Community Conserved Areas. And looking at the special legal considerations, firstly, there are the constitutional issues. Due to the fact that these areas are often administered by indigenous peoples or local communities subject to customary legal dispensations, the law needs to recognize customary law or work out how it's going to seek to recognize customary law. The law needs to also set out how it's going to anticipate blending customary law and westernized statutes to govern these particular protected areas, if they choose to accord them formal recognition. The law needs to deal with issues around communal tenure and rights, because often the land or the resources which are situated in these ICCAs are subject to communal forms of tenure. These areas are often managed by customary institutions, and the law needs to set out how they're going to deal with these institutions, how these customary institutions are going to interface often with more formal conservation management institutions. And in addition to these complex issues, the law, if it decides to incorporate these ICCAs within the formal protected area system, also needs to deal with all of these additional issues of legal recognition, definitions, forms, securing land, the management authorities and accountability provisions, access, use, benefit sharing, and incentive mechanisms. If one looks over time, and I have emphasized the fact that two forms of protected areas or three forms of governance types are receiving growing attention, namely shared forms, indigenous community conserved areas, and private forms. It's interesting to note, if one looks at the diagrams coming out of the World Database of Protected Areas, to see the shift in the different governance types. The left-hand pie chart reflects the different governance types of 1990, and the right pie chart the different governance types of 2020. There are some caveats attached to these particular diagrams, but they do depict the growth in the shared forms of governance and the forms of governance such as private governance and governance by indigenous peoples and local communities, as opposed to the historic state governance. Some general legal issues relating to these governance types. These protected areas governance types provide an essential plan context for those drafting new protected areas laws, amending existing protected areas laws to give effect to these diverse governance types, and also implementing protected areas laws. The law, through protected areas legislation, plays an important role in giving effect to these protected areas governance types, through including various different legal mechanisms. The law should be seen as an enabler. The mere fact that these particular governance types are not mentioned by name in a particular protected areas law does not mean that the law is not giving effect to them. That law should be creatively formulated to give effect to this diversity of governance types. Through a series of legal mechanisms, which I've briefly emphasized during the course of my assessment of the different 4 types of governance. I've mentioned the issue of flexibility because different governance types need to be flexible, shifting up and down their continuum often over time, and the importance of accountability mechanisms to be included in the protected areas legal system, given that often these areas are going to be managed by non-state actors. So those are the different protected areas governance types, and a short reflection on some of the issues law and policymakers need to take into account in either formulating new protected areas legislation, amending their existing legislation, or implementing their current legislation. And finally, in the remaining 4 minutes, I just want to briefly reflect on the link of protected areas governance to many other elements one finds embedded or contained in protected areas laws. If one thinks of a protected areas law, it often has to deal with the following issues: definitions, the principle and objectives which underpin or inform decision-making by authorities under the particular protected area law. The protected area law sets up the institutions tasked with making decisions, with managing protected areas. It sets out the planning framework, both the systems plan for protected areas and often the management planning frameworks for particular protected areas. The law may contain the management categories, or perhaps should contain the management categories, the IEC and management categories. The law may reflect the governance types, the IEC and governance types, or contain the mechanisms for giving effect to them. The law must provide for the establishment, the procedures to establish a protected area. Who can establish a protected area? What considerations must be taken into account in exercising that authority to establish a protected area? The law may need to provide for the amendment of the boundaries of a particular protected area. It may need to provide for the disestablishment of a particular protected area in certain circumstances. And in both the amendment context and the disestablishment context, the law needs to set out who can make these decisions, how these decisions are made, what processes need to be followed. The law needs to set out how particular protected areas are managed, who is responsible for that management, how it is undertaken. Is provision made for the creation of management plans? Are these management plans reviewed, and at what interval? What reporting requirements are created? These are issues which the protected areas law should regulate. The law needs to create the regulatory framework for activities undertaken within the protected area, how these are regulated and by whom again. The law needs to contain compliance mechanisms and enforcement mechanisms where people do not adhere to the compliance mechanisms. And finally, the law needs to deal with financing issues. How are protected areas financed? Who is responsible for financing or utilizing these mechanisms for financing and sustaining protected areas? Now, what I've purposely tried to indicate by briefly going through these particular elements is that they're all involved with the exercise of authority or decision making. Now remember that I started off by highlighting factors influencing protected areas governance. Types of decision, key actors, instruments and tools, powers and authority, and levels of decision making, with each of these issues being influenced by the law, and the law playing a significant role in shaping the types of decisions, in delineating or identifying who are the key actors, in creating the legal tools to enable people to make decisions, to set out the powers and authorities of the different actors, and to clarify the levels at which decision-making takes place, including possible delegation or assignment of the decision-making authority. And therefore, if these factors influence protected areas governance effectively permeates or infiltrates or spans every particular element contained in a protected areas law. And therefore, one needs to properly understand protected areas governance in all its dimensions, all the aspects, the legal aspects which shape it, and particularly the role of law in ensuring that it is given effect to, both in the context of ensuring good governance and in the context of ensuring a diversity of governance, a diversity of forms of authority, the governance types, which have been recognized by the international community during the course of the last 13 years. So that is where I sought to take you in the last hour. And I hope you now have some better understanding of what is governance. I hope you have some better understanding of the different legal aspects influencing protected areas governance. I hope you have a better understanding of how the international community, through various meetings, policy documents, and conventions, have sought to recognize the importance of protected areas governance and the diversity of protected areas governance. I hope you have a better understanding of the four main different governance types and briefly how the law is of key interest or relevance in giving effect to these different governance types. And finally, how protected areas governance infiltrates every aspect of a protected area law, and therefore understanding the role of law and protected areas governance is of key relevance to formulating equitable and effective protected areas laws, which in turn are central to formulating and implementing effective and equitable national biodiversity strategy and action plans. So we're nearly at the end, and I know I've run briefly over time, but I just want to remind you, all I have had time is to briefly, in a very expedited or speedy manner, introduce you to protected areas law and governance. But one has many important documents and resources which you can refer to for greater details. And I would highlight these three particular resources. Firstly, on the left, the guidelines for applying protected areas management categories. In the center, the guidelines for protected areas legislation, authored by Barbara Laushi, who you will have the privilege of hearing running the fourth webinar. And most recently, the Governance of Protected Areas Guidelines, produced by Grazie Boreni-Ferrabant and various colleagues. Do have a read through those where you'll find much more information. And if you want even further information, I return to my advert to have a look at this particular website, www.protectedareaslaw.org, which contain all the resources produced through the ISCN Environmental Law Center's Protected Areas Law Program, and much more details on what I have particularly presented here. All I have done is simply created a broad framework or a teaser or an advert for what is contained in the resources on this particular site. So that is me. And I'm going to hand back to Diego for any questions which you may have.
Many thanks, Dr. Paterson. This is a really interesting and relevant topic for our NBSAP forum members. I am sure our audience enjoyed the presentation. I want to invite our participants to share your questions, doubts, and comments, or raise your hand to participate in the Q&A session. please use the control panel of the GoToWebinar platform. We can open your microphone or read your questions wherever you want, and depending on the connection and your preference. I have a one hand raised now. Worku Jifu, let me 1 second. I'm going to open your microphone. Can you hear us? Hello? Can you hear us? Okay, while I try to connect Worku, I'm going to connect Julian Rumbelow. Julian, can you hear us?
Can you hear me?
Yes, we can hear you. Please go ahead with your question.
My question is related to productive landscapes, not only protected areas. And the question to Dr. Paterson is, are the concepts and information given today transferable as well to conservation in productive landscapes where farming and conservation are intended to coexist?
Diego, can I respond now? Can you hear me?
Yes, we can hear you.
Julian, can you hear me?
Yes, I can hear you.
Julian, I would say, you know, in those landscapes, one is often dealing with very, very similar issues. So if one was to take the different legal aspects shaping authority in a particular protected area, those same legal aspects may often shape the different forms of authority and the issues one has to address in the context of a living landscape initiative. So there's been a lot of attention, and if you're interested to read more on this particular issue, I would really encourage you to read the Connectivity Conservation Law Concept Paper, which is all about promoting connectivity, particularly between protected areas, which would include all those landscape initiatives and the other effective area-based conservation mechanisms, which I think you're referring to.
Okay, thank you.
And often in that context, what you may be dealing with are voluntary conservation mechanisms. So if you're dealing with an active landscape, let's call it a farm, and on that particular farm, you may have land which is subject to agriculture and land which is still fallow, which is of high conservation value. You may want to explore different mechanisms, not necessarily including the land of high conservation value in a form of protected area, but you may want to consider still according it some form of recognition. And the protected areas law, or alternatively a land use planning law, or alternatively a biodiversity law, could contain different legal mechanisms to grant it some different form of legal recognition, not necessarily a form of protected area, but some alternative form of recognition. Over time, as in the context of governance, the particular landowner who owns that farm may consider evolving that particular area into a form of protected area. And this is the element of flexibility which one would hope that the relevant legal framework embeds within it. One thing I find slightly uncomfortable when presenting a single seminar on protected areas law is one can never consider a protected areas law in isolation. There are so many other legal frameworks which need to be taken into account. So in your particular context, you may be dealing with agricultural legislation, or soil conservation legislation, or development management legislation, or land legislation, or biodiversity or natural resource legislation. And what you would hope is that that legislation read together with the protected areas legislation would jointly enable a diverse form of conservation mechanisms to be implemented, whether those constitute formal protected areas or whether they constitute other voluntary conservation initiatives.
Thank you very much.
Okay.
I have another question from John Pinel. John, can you hear us?
Hello, yes, can you hear me?
Yes, go ahead with your question, please.
Thank you very much. Very interesting presentation. I was interested in the idea of the private agreements, and you mentioned incentives as being an important part of that. Could you perhaps give me some examples of incentives besides financial incentives which are used to develop these private partnerships?
There's a lot of work currently going on around, I guess, around the financing of these types of initiatives. And you're right, there's been a huge push around conservation incentives. I guess other forms of incentives could be a undertaking by a conservation agency to fulfill the management responsibilities in a particular private conservation area. It could include some form of assistance with undertaking alien clearing in that particular area, or various forms of rehabilitation in that particular protected area, or assistance in formulating the management plan related to that particular private conservation area. So whilst a lot of the impetus has been on whether they're tax incentives or property tax rebates or other forms of financial incentives, there are an array of other mechanisms which could be utilized.
Thank you.
Thank you, Dr. Paterson. I have several written questions. Let me read the first one. Often, there is no one law in the singular. How should protected areas governance address multiple and overlapping laws?
I guess, Diego, that brings me back to my response to Julian, because as I emphasized there, one cannot read the protected areas law in isolation. It needs to be drafted and implemented bearing in mind these many other laws governing other substantive issues. So sometimes there's a tendency for lawmakers to employ a consultant to draft a law in isolation, to draft a particular law. And what sometimes occurs is that that consultant who drafts the law doesn't properly scope the many other legal frameworks which may be relevant or may impact on protected areas. So these could include, as I've mentioned, the constitutional frameworks, the land legislation dealing with land holding or communal land holding, the natural resource laws, the land use planning laws, the development management laws. So it's key when formulating a particular protected areas law that one needs to bear in mind these overlapping legal frameworks which are also of relevance to implementing the protected areas law. What's also key here, it raises the issue around cooperative governance. These different laws are often implemented or administered by different parts of government or different sectors in government. While the protected areas law may be administered by the conservation authorities or the protected areas authorities, these other laws may be administered by agricultural authorities, local authorities, national environmental authorities, land authorities. And it's essential when framing that law, the protected areas law, to consult firstly with these different authorities to explore ways to possibly coordinate the implementation of the protected areas legal framework with these other legal frameworks. This could be facilitated through cross-consultation across the different authorities. It could be facilitated through the creation of joint decision-making bodies with representation of these different sectors on those decision-making bodies. It could be facilitated through integrated permitting systems, so that if someone wants to undertake something which impacts on a particular protected area, the protected area authority has to sign off or be parties or signatory to that particular permit or license granted, which may impact on the protected area. So one could also think about this need for coordination in the context of planning, for instance. A particular protected area may make provision for management planning. But how does that management plan, in the context of a particular protected area, relate to the broader National Biodiversity Strategy and Action Plan, which may be regulated by a broader biodiversity law. The different laws need to talk to one another. They need to facilitate that integration, that coordination. Because if the laws don't do that, if they're not designed in such a manner, you may find the laws and the authorities administering those laws operating in conflict with one another.
Thank you, Dr. Paterson. We have just 5 minutes left, so I'm going to read other 2 questions. Resolution 30 of IUCN WCC in September 2016 addresses the need for a mechanism to find a conflict resolution mediation mechanism for the overlapping governance types of protected areas ICCAs. Which law is to be used according to WCEL?
I haven't got resolution in front of me, and I feel a little bit uncomfortable answering on behalf of the Will Commission on Environmental Law. But if we are dealing with, are they talking about a conflict resolution mechanism where conflicts arise in the implementation of a particular protected areas law, or are they looking in a more broader sense, in a more international sense? It's quite difficult to answer that question. So let me presume that they're talking in a more domestic sense, in a more national sense, where one has a conflict arising in the implementation of a particular protected area. And let's assume, for example, we're dealing with an indigenous or community conserved area, an ICCA. Let's say a dispute arises between a particular community who are managing that area and the broader conservation authority, the central authority, the national authority, who is of belief that the community is not managing the particular area which has been given formal recognition in terms of its management objectives. Well, in those circumstances, I guess I would hope that the protected area law itself would contain mechanisms for dealing with the conflict. And when dealing with that conflict, the law itself could create mechanisms for compulsory mediation, alternatively arbitration. Alternatively, the agreements setting up that particular indigenous community conserved area which regulate the relationship feasibly between the community and the state authority may itself make provision for dispute resolution procedures. Those dispute resolution procedures could once again include recourse to mediation and arbitration as an alternative to having to drag the dispute before judicial legal system or judicial systems such as the courts, which are often incredibly time-consuming and acrimonious.
Thank you very much. We have space for just one more question. I'm going to try to open the microphone of Worku Jifru, who has the hand raised. Worku, can you hear us?
Do you hear me? I can hear you, yes.
Yeah, go ahead with your question, please.
Okay, well, it's not a question, it's more of a suggestion. First, I would like to thank the presenter for a very comprehensive and informative presentation. Just a humble suggestion regarding the outline on the relevant international laws and policies, where the presenter started from 2003 of IUCN World Parks Congress. But in my view, in my humble view, it should start at least from the Convention on Biological Diversity provision, and in particular Article 8 in situ conservation, where a number of provisions are provided, where a number of provisions require parties to the convention to do something about protected areas, to establish a system of protected areas, to develop guidelines on how to select, how to establish and manage protected areas, etc. So in the framework of international law and policy, I think that's very important, Article 8 of the CBD. Thank you.
Diego, the commentator is absolutely correct, but what I've tried to do is highlight just the dates on which real concrete developments relating to protected areas governance arose. And in my opinion, those concrete arrangements really related to the work undertaken in the year in advance to the World Parks Congress in South Africa, where a particular group of people were tasked with trying to formulate a series of governance types for possible discussion at that World Parks Congress. So whilst the CPD, yes, in Article 8, does bring about some broad-reaching, relevant commitments, I do believe most of the real tangible work which was undertaken in the context of protected areas governance was really facilitated and triggered around that World Parks Congress in 2003.
Okay, thank you very much. Unfortunately, the time is over. Many thanks again, Dr. Paterson, for your time, and thank you all for your participation in this webinar. Please check out our website, nbsapforum.net, to get a list of the resources provided by this webinar. You will be able also to get a PDF copy of this presentation and the recording link. Stay tuned for our next webinar session in 14th March on establishing enabled legal conditions to implement NBSAPs. Please, for more information in the NBSAP forum, or go to the NBSAP forum or visit our social media accounts in Facebook and Twitter. Dr. Paterson, not sure if you have any other comments before finishing?
I would just once again encourage people to go and read those resources and look at those resources. You will find much more detail than what I was able to introduce you to in an hour. There are resources there for you to use, to adapt, and to enjoy. So please do go and have a look at those resources. And I wish participants in the subsequent webinars well, and particularly my two colleagues who were also involved in preparing particularly the resources around the capacity building. So my warm regards to Patty Moore, who will be presenting webinar 3, and Barbara Lashi, who will be presenting webinar 4 in, I think, 3 weeks' time. And thank you, Diego, for the opportunity. It has been an intriguing opportunity, my first experience at webinars, and let's say it wasn't as frightening as I initially anticipated.
You did it perfectly, and thank you very much. Remember to register or update your profile in the NBSAP forum. Send us your thoughts on webinar topics you would like to discuss in future sessions. I'm Diego Ochoa from the NBSAP forum. Feel free to send us your comments, suggestions, recommendations. And if you have questions related to this webinar, please send your post into the NBSAP forum. We will be publishing this webinar in the next 48 hours. Thank you very much again, Dr. Paterson, and have a great afternoon in South Africa, and have a great day for the rest of the world.